and economic loss language from H.R. 1927, the Fairness in Class Action Litigation Act of 2015. Class action suits are beneficial to consumers because they level the playing field for the little guy, consumers, working people, and small business owners. Class actions enable the weak to unite and seek justice in a court of law against a strong, wealthy, powerful, and politically well-connected corporation, just like the ones whose campaign contributions control who gets elected to Congress. An individual who has been injured or defrauded by a multinational corporation can join up with other individuals hurt in the same scheme and in the same way, and by means of a class action lawsuit, hold that corporate wrongdoer accountable in court. A small recovery, on the other hand, by a single plaintiff does not get the attention of the corporate wrongdoer, but if you aggregate a number of small claimants together and you ring the bell against a wealthy corporation with a plaintiff's verdict in court, it sends a powerful message and forces the corporation to start doing the right thing. A small claimant going it alone against a powerful corporation that comes to court with an army of high-powered, tasseled shoe-wearing, silver briefcase-toting, $900 an hour lawyers.
Mr. Johnson, if the gentleman will please stop for just one moment. This committee is a very serious committee, and we are able to accurately, I believe, understand when you talk about the merits of the case, but we do not wish or choose to be a part of a diatribe about a philosophy or about things which might drive one way or another anybody's philosophy. What we're interested in is the facts of the case as it relates to an amendment or your support therein of this legislation. And I might say to both of our witnesses that are here, it is my hope that both of you will provide this committee with the ability to effectively understand what we have in front of us, the basis, the facts of the law, or the legislation. And I would say that to the gentleman at this time. Mrs. Slaughter, do you have anything you would choose to say? Thank you very much.
Well, now,
yes,
Mr. Chairman, if I might, I would apologize for offending the Chairman.
You did not offend me. I'm simply trying to let you know that this committee has spent a great deal of time where we try and look at the basis of the facts of the case, not about a story therein.
Well, and that point is well taken, Mr. Chairman. I was just simply trying to lay out the background for the necessity of this amendment.
Well, I agree with that, but the gentleman has tried to describe who gets elected to Congress, who supports those people being elected to Congress, about the intricacies of those things. And this committee, I speak on behalf of the committee, is interested in, as you as an important witness who would come here, talking to us about a piece of legislation, not about extraneous matters. And I would ask the gentleman to please confine his remarks to the committee so that we're able to do our work also. We spend sometimes excessive amount of time up here, and sometimes it is completely in line that we have to ask a lot of questions that may extend the time, but that we try and focus on and have very exemplary members of this committee, including a former federal judge, including a biologist, including a PhD in economics education, including a gentleman who himself is a very bright lawyer, and a lawyer of a physician of enormous capacity. And we do look to each other to try and resolve those matters extraneous to legislation as we apply them. So I would simply say to the gentleman, politely again, I am going to ask that you please confine your comments directly to the legislation.
Well, thank you.
Therein. Thank you. Thank you. Recognized.
Thank you, sir. And I would just conclude by stating that the scope and economic loss language in the bill unfairly requires plaintiffs to prove the merits of their case twice, once at the certification stage and once during the trial on the merits of their case. And by prohibiting a court from certifying a class action unless all class members have suffered exactly the same type and scope of injury as the named class representative, if that's the requirement, then this bill would let the very powerful corporations that Americans need to sue in class actions effectively prevent any future consumer class actions from proceeding. The scope language would eviscerate many claims, including those stemming from defective products, fraud, price fixing, civil rights code, antitrust, mass consumer breach of warranty, business loss claims, and theft of basic lost wages, as it is virtually impossible for large groups of consumers or businesses to prove that their harm is exactly the same as the harm sustained by the named plaintiff. So, for example, the owner of a vehicle that has been recalled with a steering defect should not have to also be mangled or killed in a catastrophic accident the way the named representative was in order to be eligible for certification in a product defect class action. Pursuing such actions is very complicated and requires significant resources not available to the individual consumer, but justice for the little guy is possible when injured parties band together in a class action lawsuit. Class actions make it economically feasible for these individuals and small businesses to seek justice against multinational corporations with significantly more resources. The scope and economic loss language contained in H.R. 1927 would make these procedural hurdles even more burdensome and make the justice for the little guy impossible by slamming the courthouse door in the face of those who need it most. The scope and economic loss language should be stricken, and I would ask for your support in this amendment, at least in making it or ruling it germane. And with that, I yield back.
Thank you very much, Mr. Fitzpatrick. Welcome to the Rules Committee. Delighted that you're here with us today, and the gentleman's recognized.
Thank you, Chairman,
Yes,
and members of the committee for the opportunity to speak to the amendment that I've offered. It's an amendment to the Class Action Fairness Act, which rights a wrong by ensuring fairness to victims of unsafe medical devices by allowing their cases to be heard by the courts, which is a right in this particular case I want to talk about today that is being denied. While many medical devices prove life-saving, we know that some can cause harm and have devastating consequences on patient health. In fact, I can guarantee that each and every one of us has constituents who are harmed by an unsafe device, whether it's a power morcellator, a pelvic mesh implant, a redesigned blood clot filter, or the permanent contraceptive device, Ensure. And so I think everyone would agree when a medical device is not safe, we should work to remove it from the market, and those harms should have recourse